Stewart.
Good afternoon. I was just about to take you to the explanatory notes, which are mercifully extremely brief. The explanatory notes to the Corporation Tax Bill 2009, the relevant note is on page 2376. And it's paragraph 3089 in the middle of the page, which refers to subsection or subclause at that stage 3 of clause 219. And it simply says it excludes capital expenditure in terms that follow closely the trading income rule. And then it makes another point which is not particularly relevant. There is a little more in the explanatory notes to the 2004 bill when this provision was first brought in, and that's at page 2338.
So the first one was explanatory notes to the bill or to the legislation?
That's the bill, the Corporation Tax Bill 2009, which of course is the act that we are concerned with.
So these are the notes that the Treasury will made available to Parliament to explain the purpose of the provisions.
I imagine the reason for the MPs having this, if they look at them, is to explain, yes, what the provisions mean, what they're about. Exactly.
And they're made available to members of the Parliament under the authority of Parliament.
They are, yes, that's right.
Well, I see.
I think that's right.
Parliament allows them to be distributed to members.
Yes, they're not. I don't think they're authorised. These are explanatory notes that are produced for all bills nowadays.
Yes. The ones we're just looking at, the particular paragraph you were drawing our attention to was one at 2376. 2376,
yes.
Which paragraph were you?
It's paragraph 3089 in the middle of the page, which refers to
I see.
Subsection 3, although strictly it's subclause 3, I think, at that stage. But if you look back over the page, this is in consideration of clause 1219 of the bill, which became section 1219.
Oh, I see. That's B, isn't it? Yes, I see. Right. Okay.
They seem to rather inconsistently refer to subsections within these notes, but anyway.
Thank you.
And then, if we turn back to page 2338, so this is when this provision, the capital provision, was first introduced in 2004 in the Finance Bill 2004. So these are the explanatory notes to the Finance Bill 2004. And it's page 2338, and it's paragraph 10 on that page. Provides the new section 75.3 provides that expenses of a capital nature are not expenses of management. This is subject to 2 exceptions, and then they list them. The second exception, slightly interesting, which is, if you look at the last 3 lines, this ensures, for example, that the expenses of establishing a share option or profit sharing scheme treated as a management expense by section 84A are not disallowed by the general prohibition of capital expenditure. Now, the reason that might have been a concern is the seminal case of Atherton, you may remember, because Atherton was actually about the establishment of a pension scheme. And what was said in Atherton is that the costs of establishing a pension scheme are capital. Atherton is a case you'll see referred to in almost every case on capital and revenue. It's always the starting point. But that's what the case was actually about. And so the concern might be, if you apply that might somehow override the allowance of these costs as management expenses. And that this was to just make it clear that they didn't. And then the next paragraph gives the context of this provision. The Inland Revenue has always argued that capital expenditure is inadmissible as an expense of management investments under the current rules, but the High Court has recently found against Inland Revenue on this point, referring to Camas in the High Court. Inland Revenue is taking its appeal against this decision to the Court of Appeal, but the hearing hasn't taken place yet. If there was any doubt that this was a response to the decision in Camas, that makes it clear. So all I really rely on these notes for is to show that there wasn't anything strange going on here. There wasn't an intention of Parliament to introduce some unusual limited provision, as my learned friend suggests. It was straightforward.
In paragraph 10,
Yep.
did that new section do something different from the present section? Because there it describes it as saying that expenses of capital nature are not expenses of management, but that's not what the provision actually...
It's not accurate, I agree.
Right.
Strictly accurate. They are expenses of management, but they're not deductible.
Yeah.
Yes, they're excluded from the deductible expenses.
Yes.
Yeah.
But I think perhaps, as an explanation to lay people, that might be a little bit pedantic. So I think this is giving them the
But the mechanism
result
was the same in the 2004
it was the
Act,
same, yes. My next point was about the inconsistency and illogicality of the argument that's being put forward by the appellants. The appellants accept, as I understand it, that investments held by an investment company are capital assets for these purposes. They also accept that other capital assets, such as buildings and plant and other assets owned by the investment company, are capital assets. But then they say, despite that fact that they accept their capital assets, they limit the expenditure on acquiring, disposing and improving those capital assets to the expenditure, effectively, which is not an expense of management. In other words, they limit the extent of what is capital to what is not an expense of management. And we know that that is obviously much narrower than the expenditure which would be capital under normal principles. I'll come on to that. So it's really difficult to see how you get to that conclusion, having accepted that these are capital assets, that certain expenditure on acquiring, disposing and improving of them is not capital expenditure within this provision. Then fourthly, my point is that there's nothing in the judgment of Mr. Justice Patton in Camas which casts any doubt on what was said in the House of Lords in Sun Life, that the costs of acquisition of an investment are not expenses of management. And if we could just look very briefly at the judgment, but I can show you quite quickly that, in fact, the opposite is the case. It begins on page, I think, 1849 in the authorities bundle. The judgment of Mr. Justice Patton. And if I could take you forward, first of all, to page 1863, paragraph 32, when he says, "This brings me to the main issue on this appeal." And in particular, the last few lines, just above letter I, "For this reason, when considering costs incurred in relation to the purchase of an investment, The approach of the courts in decided cases has been to separate expenses of management from what can properly be regarded as costs of the acquisition itself. The leading case is the decision of the House of Lords in Sun Life. So that's the starting point of Mr. Justice Patton. He then quotes from passages from the judgment in Sun Life, including passages from Lord Morton, who says on page 1865, at D, these expenses are, however, so closely linked with the transaction of purchase that they may naturally be considered as items in the total cost of a purchase, which has already been resolved upon by the management of the company, and not as expenses of management. This is the short and simple ground upon which the Special Commissioner decided the case in favour of the Crown, and I have arrived at the conclusion, with considerable doubt, that it is sound ground. So those are the passages I think my learned friend has shown you. And then if we move on to page 1867, paragraph 36, I have quoted at some length from the speeches in Sun Life because both parties accept that they contain the law which I have to apply. Mr. Prosecutor for Camas invites me to accept as the correct test the question posed by Lord Reid as to whether the costs under review should be regarded as part of the costs of acquisition or something severable from it, which can properly be regarded as an expense of management. And the Crown has accepted in its Skeldon argument that this is the true test, or at least the most helpful formulation of the test in the present context. I agree with that, and then the real difficulty is its application to the facts. So there was agreement on all sides that this was the correct approach. And then if we move on to page 1870, paragraph 43, he says, in my judgment, the Special Commissioners have misapplied the Sun Life test to the facts of this case and appear to have asked themselves a different question. The speeches in Sun Life indicate that the correct approach is to draw a line distinguishing between management expenses and expenses or costs which are properly to be regarded as part of the costs of acquisition, i.e. the purchase price. An expense is, to use Lord Reid's word, if severable from the cost of acquisition, if objectively viewed it is not part of the purchase price. This is a matter of judgment in every case. Then he goes on to consider it. And in paragraph 44 on the next page, he says, it seems to me that the correct answer to Lord Reid's question is that the expenses under consideration are not part of the costs of acquisition. And then he goes on to explain that. And then he refers to the Hibernian case where the Irish court came to a different conclusion, and he says he doesn't agree with it. But one can see that the whole of this case has been argued and decided on the basis that the costs of acquisition are not expenses of management. So we would submit there's just nothing that you could get from this which would make you concerned that there was a doubt about whether the costs of acquisition are expenses of management. And finally, we have the argument from absurdity. And we would adopt, in this regard, the closing words of Lord Sales in PACCAR, cited in the appellant's case at paragraph 110. Where he says, right, this is at the end of it, the passage which they cite, I would add that the courts have to be careful to ensure that they do not rely on the presumption against absurdity in order to substitute their view of what is reasonable or for the policy chosen by the legislature, which may be reasonable in its own estimation. The constitutional position that legislative choices for Parliament cannot be undermined under the guise of the presumption against absurdity. Now, we do say that there is no absurdity in the position here. The absurdity which my learned friend seeks to set up is that if we are right, this will result in little or no scope for any relief under section 1219. But as my Lord Richards rightly said, that is simply incorrect. There is a huge amount of scope for the application of expenses of management, and this decision will make no difference going forward to the amount of expenses of management that have been given in the past and will carry on to be given. There's very considerable amounts, you won't be surprised to learn, very considerable amounts of expenses of management are given currently. It's measured in the tens of billions.
Under this provision, 1219?
Well, it's been in force for the last 20 years, so yes, that's currently what's given, yes. Under it, as interpreted by the revenue, now there'll be much more, I imagine, if Cole's argument is correct, because of course a lot more expenses will qualify as expenses of management, or deductible expenses of management, rather. But as things stand, under section 1219, as it has been operating for the last 20 years, yes. And that's because it's not correct to say that any expenditure that is incidental to a capital asset is capital. That's just simply incorrect. The true approach, and we'll come on to look at this, is to focus on the capital asset and to look at whether there is a acquisition, disposal, or improvement of the capital asset. And if you have expenditure on one of those categories, then that will be capital expenditure. But if you have expenditure, day-to-day management costs of capital assets, that is not capital expenditure. And I understand, sorry, this is again me giving evidence, but I understand that the bulk of the capital, the expenses of management that are given are in fact staff costs of investment companies of various types. Of course, there will be other costs, but the bulk are staff costs. And they are managing the investments in all sorts of different ways. Of course, there are different, I think as my learned friend points out, there are very different types of investment company. There's this type of investment company in a group which owns subsidiaries in a group, which may get very involved in the management of the subsidiaries as part of its job of managing investments. Whereas there are other investment companies who simply own small shareholdings. Or there may be those who are, those who are sort of unit trusts or things like that, who own small shareholdings, won't get involved in the companies, but just will hold the shares as investments and get income from them.
Even they are different from a third kind of company, which is buying and selling shares to sort of make money on the rise and fall of the share price.
If they're buying shares for to sell them at a profit,
yeah,
they'll be trading. They'll be a dealing company. They'll be carrying on a share dealing trade, and they'll be taxed completely differently. Such a company may have capital assets, of course, as well. Yes.
But it's not an investment company within 121.
It would not be an investment company unless. Well, now you can have an investment company which has a trade and an investment business. So if they had an investment business as well, they would be an investment company in respect of that. But there is a very important distinction between traders and investors. And that's a point I'll come on to briefly, but show you it's been made a number of times in the courts in the past that in order, the starting point is you've got to look at the business that's been carried on, because the fact that they hold, say, policy, they might hold insurance policies. Well, they might hold them as investments, but they might hold them as trading stock because they might be dealing in them. You can't tell until you look at the business to determine what the nature of the business is. But we don't have that question here because we know the nature of the business. It's not a dealing company, it's not a trading company, it's an investment holding company. But yes, my point was there are also all sorts of variants between very small investment companies, maybe run by one man in his back bedroom, and large investment companies who hold lots of shares but are holding those investments and getting income from them and occasionally selling and buying but not dealing in them. And there's all sorts of in between. There's going to be a whole range. The other kind of investment company that is now taxed as a trading company are companies which hold land, essentially, for income. Property, what they call property companies, property holding companies, and they are now, well, I say now, but for a number of years, they have been deemed to be taxed as trading companies, or at least many of the provisions applying to trading companies have applied to them. But originally, they were all taxed as investment companies, because they are an investment company, essentially. And one of the points that we made below was Section 53 of the CTA has applied, or its predecessor, to these kind of companies for years without any difficulty. I wonder if I could just briefly show you the provisions so that you've seen them. It's in the authorities, page 1096. And I apologise, but the provision which defines property business is not there. It's section 205. Unfortunately, it's not. But basically, it's a business of generating income from land. It's what is a property business. So the profits of a property business are calculated in the same way as profits of a trade. That's section 210(1). But then only certain provisions of Part 3 are applied. And there's a list of provisions that are applied, and one of them is Section 53, you will see capital expenditure. And our point below was, well, this shows that this capital provision can apply to companies that are essentially investment companies because they're holding land for income. There's no problem with that. And it does apply in its full, normal vigour. The appellant's response to that was, well, the drafting technique here is different. Rather than setting the provision out in longhand, as they've done in section 219, what they've done is said it's to be calculated in the same way as the profits of a trade, and incorporated section 53 by reference. And they say that makes all the difference. If we'd done that in this case, then we would probably have a different result, it seems.
So where did they set that out? Which section are you referring to?
Section 210, sorry, of the...
Yeah.
That's the one which says the profits of a property business are calculated in the same way as the profits of a trade. The reason for that is, as I said, before these provisions were brought in originally, a property business was just taxed as an investment company, because it is an investment company essentially. It's just the investments are land as opposed to shares or others. And my final point on this, construction point before I turn to round two, is just to stop a moment and think about the consequences of this different treatment that the appellants argue for. One of the cases in the bundle that's referred to below is ECC Quarries. I've mentioned this already. What happened in that case was that the company was a trading company, and it wanted to get planning permission for a change of use of some of its quarries. And this involved, of course, having a public inquiry, having to engage lawyers, etc., to achieve this. And the question was whether all these expenditure on lawyers, etc., to obtain the planning permission was capital or revenue, and the court decided it was capital because it was expenditure incurred to either create a new asset, being the planning permission, or perhaps more sensibly, to improve the asset that they already owned. Now, that's a trading company. So if you have a trading company which owns a building that it wants to obtain a change of use for, and I was inspired to thinking about the Marks and Spencer's building in Oxford Street, where there's been a lot of controversy over the last few years. They've been seeking to obtain planning permission for a change of use. That has resulted in an enormous amount of legal expense, I imagine, in inquiries, judicial review, etc. If they're a trading company, there's no doubt that would all be capital and not allowable. But it seems the appellants would contend that if it was in fact an investment company which held the property and let it to traders and then sought to have a change of use, then all the expenditure incurred on obtaining planning permission for a change of use would be at expense of management, and therefore immediately deductible by the investment company. And we would submit that simply can't be right, that two companies doing the same thing should be treated so differently in tax terms, and it would be contrary to what Parliament was intending to do with Section 1219(3).
You could take a simpler example, I suppose, and simply say, supposing Marks and Spencer just wanted to sell the Oxford Street store, and they engaged advisors in relation to the sale. Would those be expenses of a capital nature? I mean, that's a precise analogy, I would suggest.
If they're a trading company, then it clearly would be. If they're an investment company, then that's the issue the issue we're dealing with.
But how does Mr. Rivett was talking about the scale, took us to the findings of fact about the scale of this. Does it make any difference that Marks and Spencer has hundreds of stores across the country, so at any given time it's probably buying or selling or improving one of them, and so it is a sort of day-to-day thing? No,
it doesn't make any difference, and I'm going to show you. If it's a capital transaction, then if you do 100 capital transactions, they're still all capital transactions. Doesn't make any difference.
What is this recurring nature of it point then?
Well, we say that it's irrelevant. That's the appellant's argument. We say it's irrelevant to the question of whether something's capital or not.
Well, that's probably maybe putting it a bit high. I mean, Norman Wisdom was taxed as a dealer in silver because he was doing it lots of times.
Yes, I prefaced it by saying if it was a capital transaction.
But he was arguing it was.
Oh, he was, but he was wrong.
Yeah, well, quite. But I mean, the frequency with which he was doing it was.
It might make it a trading. It might result in it being trading. Yes, I agree. But the point I'm making is that if it's not trading, the number of capital transactions you carry out is irrelevant. You can carry out 100, and there's plenty of authority for that. Plenty of authority. I'll show you. There's a case about butchers, which is referred to, who were doing it all the time.
It's a slightly different one, isn't it? It's in the nature of being a holding company, and it's part of the routine activities of an investment holding company that it is looking at acquiring or disposing or improving its investments, and that puts it into a different category from a retail chain, for example. I don't think he's necessarily disputing the Marks and Spencer's example, but what he's saying is it's because of the special nature or particular characteristics, should I say, of an investment holding company that you can't look at it in quite the same way.
Well, I understand that, but of course, trading companies will be monitoring and looking at their capital assets as well. They don't just sit back and leave their stores,
isn't it? I mean, the entire activity of an investment holding company is directed to its investments, whereas that's not true of the ordinary trading company.
But we say that doesn't matter, because what you're looking at is whether they are disposing of a capital asset, and that's a capital transaction. It's much simpler than I'm afraid my learned friend's making out. There's no question of looking at whether it's an important part or a less important part of their business. And I understood one of my learned friend's arguments was that this was actually a small or unimportant part of their business, which is rather strange.
Well, I think that was, as I understood it, directed to the point that I was making, which is that this is a day-to-day occurrence for them to be looking at buying, selling, improving these businesses.
Now, this is one of the points in their case that they make, which they say a significant factor in this is that this is a small. This wasn't an important part. They were contrasting the large amount of activity they carry on with how small this particular part is. And again, we say that's completely irrelevant. A very small asset can be a capital asset. It's not a question of looking at the importance of it. I think the day-to-day point, they do make that, and that is an important part of their case in my submission. And you find that in their case at paragraph 141. I think in many ways this is the nub of the appellant's case on the law. Because they say in paragraph 141, each of these principles is in substance concerned with the identification of a dividing line between expenditure which is ordinary or normal expenditure, rather than expenditure which relates to the fundamental organisation of the trade or business. And they refer to Van den Berg's, identifying that they were not ordinary commercial contracts. But that is a distinction that is drawn in Van den Berg's, it is true, but that is in a particular context of that case. In Van den Berg's, there wasn't an identifiable asset. What happened in Van den Berg's was that there's two companies selling margarine, and they had a very strange relationship between them. They had
What?
A strange relationship between the two
What were they
companies.
selling?
Margarine.
Margarine.
Margarine. I thought you said margin. It would be more.
Margarine. Not something you hear much about anymore, but yeah.
Well, when we were younger, there was the comparison between butter and margarine.
Yeah.
That seems to have gone.
Yes. I can't believe it's not butter. Exactly. So they were selling margarine. Perhaps if we could just, might be useful to take you to that case. It's on page 1322. I hope. Relying on your reference. So, if you just look at the head notes on page 1312, and you will see it's a very, it's an extraordinary case, really. And so one of the companies brought an end to these arrangements and paid £450,000. And the question was whether this was capital or revenue. And if we look at page 1322, we'll see the conclusions of Lord Macmillan. This is the final paragraph on 1322. The three agreements which the appellant consented to cancel were not ordinary commercial contracts made in the course of carrying on their trade. They were not contracts for the disposal of their products or for the engagement of agents or other employees necessary for the conduct of their business, nor were they merely agreements as to how their trading profits, when earned, should be distributed as between the contracting parties. On the contrary, the cancelled agreements related to the whole structure of the appellant's profit-making apparatus. They regulated the appellant's activities, defined what they might and what they might not do, and affected the whole conduct of their business. I have difficulty in seeing how money laid out to secure or money received for the cancellation of, or so fundamental an organisation of a trader's activities, can be regarded as an income disbursement or an income receipt. Mr. Hills very properly warned your lordships against being misled as to the legal character by its magnitude. For magnitude is a relative term, and we're dealing with companies which think in millions. But the magnitude of a transaction is not entirely a relevant consideration. The legal distinction between a repair and a renewal may be influenced by the expense involved. In the present case, however, it's not the largeness of the sum that is important, but the nature of the asset that was surrendered. In my opinion, that asset, the congeries of rights which the appellant enjoyed under the agreements, and which for a price they surrendered, was a capital asset. So in the very exceptional circumstances of this case, the contracts that they entered into with the other company were regarded as a capital asset. And normally, a trading contract would not be a capital asset. And if you are paid to bring it to an end, that would be a revenue receipt. It would be replacing the profits, essentially, that you would have made under the contract. And that was what the revenue were arguing for in Vandenberg, that this should be treated in the same way. But that was rejected by the House of Lords. So it's in that context that one talks about the distinction between ordinary commercial contracts and this very unusual contract or contracts in Vandenberg's. But that is not the touchstone or dividing line between capital and revenue, generally. The question that you're asking, and it was in fact the question that they were addressing in Vandenberg's as well, is whether this is a expenditure on the disposal or acquisition or amendment of a capital asset. And what we will see when we look at, I hope not too long, Granada and Strick, is that is the approach that the courts and the highest courts have adopted. The starting point is that you look for an identifiable asset capital asset, not trading stock. You look for identifiable asset. Now, in some cases, there won't be an identifiable asset, and there are some difficult cases where the courts have wrestled with whether something which is not an asset can still be treated as capital. And we'll see that in Strick. I'll come to that in a moment. But where there is an identifiable asset, in my submission, the answer is clear. And those are not the cases that you end up being argued in the House of Lords in general. Not anymore, anyway. So can I move on to ground 2, which is assuming that we are right on ground 1, that we are simply applying the conventional orthodox principles from the authorities. And my first submission on ground 2 is that the statutory provision refers to expenditure of a capital nature. And therefore one has to start with the expenditure in question and decide whether it is of a capital nature. My second submission is if the expenditure is for the acquisition, disposal or improvement of a capital asset, then its nature is capital. And the clearest exposition of that is actually a passage that my learned friend showed you from Lord Gough in Lawson and Johnson Matthey, which is at page 1700 of the authorities bundle. So it's the passage, it's the final substantive paragraph. It's important to observe that the payment does not become a revenue payment simply because JM plc paid the money with the purpose of preserving its platinum trade from collapse. That was the approach of the General Commissioners, which I do not feel able to accept. The question is rather whether on a true analysis of the transaction, the payment is to be characterised as a payment of a capital nature. That characterisation does not depend upon the motive or purpose of the taxpayer. Here it depends upon the question whether the sum was paid for the disposal of a capital asset. And in that case, he concluded that the £50 million paid by the company was not for the disposal of the worthless shares in the company that was being rescued by the Bank of England. He says the sum was not paid for the disposal of the shares, it was paid as a contribution towards the rescue of GMB, which GM plc knew the bank was going to amount immediately in the public interest. So it was a revenue payment in that case. Obviously, we don't have a factor like that in the present case. We're looking at payments to professionals for services, so there's no question of something else being involved. This is, my third submission, this is a matter of objective analysis. As Lord Gough made clear, which is a question of law for the court. And fourthly,
just before you leave that, the Court of Appeal at paragraph 87, did they take into account, depending on the purpose for which it was paid, relying on wharf properties?
Well, I think they made it clear that by what Lord Hoffman was talking about in wharf properties was objective purpose. He wasn't talking about the motive
Right.
in the minds of the taxpayer.
Right.
Yep.
Yeah. Okay.
So my fourth submission is this question is answered by determining, and that's why this is a question of law, not a question of fact. Many,
Purpose is,
if it was a question
purpose is different from motive.
subjective
Purpose
purpose,
or-
I think he's talking about objective purpose, not the subjective purpose of the particular taxpayer. That's the point I was making.
Subjective purpose and motive are the same. It's objective purpose.
Yes,
That's
objective
what we're looking
purpose.
for. Yeah.
Yes, Lord Hoffman uses the expression comparing the electrician constructing a building and the electrician repairing a building.
Exactly, yes. Yeah. But it doesn't depend on anyone's subject. That's the point. It's not a question of subjective purpose. If it was that, then it might well be a question of fact, because we've got a lot of cases about purpose, obviously in tax, where it essentially is a question of fact, what someone's purpose or main purpose is. Many anti-avoidance provisions have that.
Okay.
One of which we were debating
Yeah.
not long ago. My fourth submission, this question is answered, the objective question, by determining what call obtained in return for the expenditure in issue.
Sorry, could you just repeat that? Sir?
Yes, this question is answered by determining what call obtained in return for the expenditure in issue. Can I then take you to the findings of fact of the First Tier Tribunal, the relevant, we would say the relevant findings of fact in relation to this issue? And can I just, before we look at the various advisors, can I just take you to paragraph 23? I'm sure that you've come across this, you've looked at this, but it explains what held for sale means in the accounts. In my submission, it makes clear that this was a very firm decision. This is paragraph 23 of the FTT's decision. Held for sale is an accounting term of art and defined by IFRS 5. A disposal group is to be classified as held for sale if its value is to be recovered principally through a sale transaction. The disposal group must be available for immediate sale in its current condition, and a sale must be highly probable. For this to apply, management must be committed to a plan to sell the asset and must have initiated an active programme to locate a buyer and complete the plan. It must be actively marketed for sale at a price which is reasonable in relation to its current fair value. It should be expected the sale will complete within a year.
So when was it? It was regarded as held for sale by July 2009.
At least, yes.
That's when the accounts, the half-yearly accounts.
Yes, that's when the accounts appeared anyway. It wouldn't appear in the accounts before then, I suppose. But,
Well, the June decision was just before that.
yes. But that makes sense, because if in June they had instructed the professionals, then that would fall within, they've initiated an active programme to locate a buyer and complete a plan. They had by that stage, only just.
Yes, I'm just wondering how one finds this boundary in practice between the moment that it switches from just getting general advice. Suppose they'd used the same lawyers all along. They had external lawyers who helped them with all sorts of things year on year on year. You would be looking for a point at which that stopped being just general advice to the business and hence an expensive management to being an expensive management of a capital, being an item of a capital nature, and what do you look for in that?
Well,
This at least is some kind of objective thing which one can assume is not is not just reliant on what somebody puts in the minutes of a particular board meeting.
No. I mean, this is not, I don't want to give the impression that we say, we don't say that from a particular time all expenditure is capital, whatever it is. What we're saying is a combination of the fact that they had clearly made a decision to sell, a very firm decision to sell, and then when you look at what they engaged the professionals to do under the contracts, and indeed what they did do, which was consistent with that, that's what indicates that the expenditure, particular expenditure we're looking at, is expenditure on a sale or for the disposal. So it's a combination of these two things.
It's a combination of the fact that they had made a very firm decision to sell.
In this case, a very firm decision, yes.
Well, there must be a test that you apply as to when it becomes, when legal advice or financial advice becomes expenditure of a capital nature. What I'm trying to understand.
Well, I think the only test, the only test you have is whether, it's a very brief one, as to whether the expenditure is on or for the disposal. But to determine that, you've got to look at what the expenditure was and how it relates to the disposal. So in this case, we would say, I'm just going to come on to that, if you look at what they were actually engaged to do, Deutsche Bank, PwC, and then De Broglie as well, it was all aiming to achieve the disposal. So can I take you to page 168? Sorry.
Just before you do that, so that I fully understand, you said it's a combination of those factors. Okay, take out of that list the firm decision to sell, and what's the position then?
Well, if you engaged, sorry, if you were to have engaged, done the rest of, then I think one would assume that you made a decision to sell. Yeah. All I'm pointing out here is we also have independent evidence that they had made a firm decision to sell. So I would be saying, if we didn't have that, you'd be wondering why they were suddenly engaging Deutsche Bank, PwC, etc. But assuming that they had there's no other evidence, the board hadn't said anything about it, they just suddenly out of the blue engaged Deutsche Bank on these terms, then I would be asking you to infer, or not you, but the tribunal, I'd be asking the tribunal to infer that they had made a decision to sell, otherwise why would they be engaging these people? Just as if an ordinary person goes along to estate agents and whatever and puts his property on the market and engages them to sell it, you might assume that he's made some decision to sell. Of course, he may be testing the market.
The test is, what is the money spent on? Is it expended on or for the disposal?
Yes.
But you're saying in this, on the fact matrix we have in this case, you can rely on the combination of a firm decision to sell with the engagement of professionals who were all looking and doing things directed at the sale.
Yes. Those are both pointing in exactly the same direction. They're both.
Yes, I mean, so you've got the firm decision to sell, the nature of the instructions given to the professionals, and the work which they in fact carried out.
Yes.
And you're saying, well, even if you didn't have the firm decision to sell, you might have been able to make a case based on the latter two considerations, the instructions and what they did.
Exactly. I think you would possibly infer. You would probably be able to infer if there was really no other evidence.
Infer the first thing, but
you could infer the first thing, but we don't have to in this case.
But here you've got sort of paragraph 20, 23, 121, and so on for the firm decision.
Yes. So we know for sure that this is this is part of the sale, the decision to sell, and then engaging the professionals. And it's important then to look at paragraph 64. And on page 168 in mine, there's a list of what Deutsche Bank will do, which begins with familiarise itself with the business, operations, financial condition and prospects of Oxio and Greenmont businesses, assist Centrica in identifying and evaluating counterparties for potential transactions, assist Centrica in identifying and evaluating potential assets held by the counterparty, which could be of interest under an asset swap, so that's one type of transaction. contact potential counterparties, meet with representatives of potential counterparties, provide such representatives with such information, etc., advise on the structuring, pricing, sizing, timing of the transactions, advise on the external presentation of the transactions, advise on the marketing of the transactions, including preparation, coordination, and presentation of sales documents, assist in the production of announcements, circulars, documents to implement the transaction, and then render such other advice, assistance, and services as may be reasonably specifically requested in connection with the transactions. And then that is what actually happened. And we know that from all the findings. I'm not going to read them out.
There were the two elements in 66. I think the additional incentivisation fee, that was held not to the expenses of management at all. Is that right?
That wasn't claimed by...
Oh, wasn't claimed.
That was conceded for some reason, which I don't really understand. But Cole didn't claim that particular fee, so we never had to go into it. But it seems to me that it should stand or fall with the other.
It was contingent, sorry.
Yes.
It was contingent on a sale being achieved.
Both are contingent.
Oh, both were?
Yeah. I think B is kind of completely discretionary.
Ah, okay, sorry.
I think that's the difference. So I think the first is...
But the 2.5 million euros is still disputed before...
Yes, that's what we're arguing about. And that's the bulk of what we're arguing about, really, actually. The other fees are more modest, certainly smaller. So it's that. And you're quite right, my lady, to point out, this fee is conditional on the sale going through. And to suggest that this is a fee being paid, expenditure being paid, simply for advice as to whether or not to carry out the transaction, in my submission, well, it flies in the face of the documents, obviously, but it also flies in the face of common sense. You wouldn't ask a professional to advise you on whether to go ahead with the transaction if he was only going to be paid if you went ahead with the transaction. That would be a really most peculiar kind of instruction. So we also rely on all the findings from 68.
I don't know if you referred us to it, but in paragraph 63, the transactions are defined, as is the Oxio transaction,
Yes.
which is the one that's referred to in paragraph 66.
Yes, there is.
So that's what it's all directed to.
That's what directed, yes. Exactly. So yes, we rely on what is said between paragraph 68 to 93, which in my submission simply bear out exactly this. Now, it is true, of course, that at some stage in this, there was some doubts expressed, and there was no doubt advice as to whether to carry on with the transaction or to carry on with the sale as part of the services provided by Deutsche Bank.
Yeah, well, paragraph 71 makes clear that the strategic decision to divest had been taken, but how to do it wasn't yet determined, and there was a possibility that it mightn't go through.
Yes.
But you say that possibility doesn't alter the nature of the services being provided.
Absolutely, that certainly doesn't. I mean, we know, for instance, that abortive expenditure on an abortive capital transaction is capital. And so it can't make any difference that it was doubtful. But more than that, I would say the fact that they did, as part of this process, give some advice as to whether they should carry on selling or whether they should sell part of the business and retain part of the business. That is all part, in my submission, of the process of selling. And is exactly the kind of advice you'd expect a sales agent in a more straightforward transaction to give. But you have to ask the question, you have to think, supposing this process had gone through smoothly, supposing they'd found the buyer had been very keen to buy the Oxio businesses because they thought, although Centrica was making losses, they could run them better. And they had gone through the process, due diligence, etc., and they had bought the whole lot. Would that have made any difference to the answer? Deutsche Bank would have been paid the same fee under the same contract. They'd have done the same work. They'd have found the buyer. They'd have negotiated with them, etc. Could it possibly make any difference to the answer to the question? In our submission, clearly not. The nature of the expenditure can't change because the transaction becomes more complicated. So these are the findings we rely on in relation to Deutsche Bank. And then PwC, now you have to realise, I'm sure you do, that there are two reports for PwC. There was the report I think they were originally asked to do, which was the vendor due diligence report. And this was to be made available, this is paragraph 95 of the FTT decision, made available to potential purchasers. PwC would discuss the report with them, and PwC might assume a duty of care to the bidder, so they could rely on it.
As independent accountants.
They were acting semi-independent, yes, I think it's fair.
Yes, well, they were instructed by the vendor, but were undertaking a duty of care to the purchaser.
Well, they might. I think it says here, at a later stage, PwC might assume a duty of care. So if the purchaser said, we'd like you to be on the hook, then they might do that. I don't know whether there was going to be another fee for that. Or
at a price, perhaps, yeah.
Yes, there might be. But that was... But what their role was in relation to that report was certainly to provide it for the purpose of the sale, so that there would be something. I think you might... It's a bit like a survey of a house. You know, you've got a due diligence report of a company, business, to show the purchaser, you know, this is what it's all about. Now, there was another report that they did with a deep dive, and that was part also of the sale process, because of course Centrica wanted that to discover what was wrong and what they should do. There's never been any separate argument about that report as to whether it would be treated differently from the others. Cole have never sought to differentiate it. I could certainly see, if we were arguing about anything in this case, that report would be one that you might argue about. But we would certainly be submitting that it is also just simply part of the sales process. And the findings on that are paragraphs 103 to 106.
Really.
And you'll notice in 104, notwithstanding the serious problems that we identified, the 2010 half-yearly accounts of Centrica stated the group intends to dispose of Oxio as soon as practicable, etc. So it wasn't that the sales process was interrupted, it carried on. And then finally on De Brouw, we have their engagement is at it's paragraphs 107 to 108, and we would submit these are all matters in relation directly to the sale, matters of Dutch law, because of course the company and the businesses were in Holland. And what De Brouw actually did is set out paragraphs 111 to 118. And we would submit in summary that these were all services which were directed to achieving the disposal. This was not strategic advice on what assets to keep and what to sell. The strategic decision to divest had been made, and we would submit this is the practical implementation of that decision, and all of these professionals were involved in that. Now, could I then just briefly show you at this stage a couple of the important cases on the correct approach to be adopted? The first one is Regent Oil and Strick, which I think begins on page 1437 in the authorities bundle. This case emphasises the importance, in my submission, of the identifiable asset. This concerned petrol ties. Now, the history of these petrol ties at that time is set out by, is explained by Lord Reid in his judgment at page 1453C to 1454G. This had been a developing area in the petrol industry. Contractual ties, purely contractual ties, were considered in an earlier case called Bolam and Regent Oil, which you'll see referred to, which was decided, I think, in 1956 by Mr. Justice Dankworth. And they were held to be revenue expenses. Now, the petrol stations appeared to have the commercial upper hand at this time, as far as I can understand, and they decided to insist on a lease and leaseback structure. How this worked was they would grant a lease of the petrol station to the oil company in return for a premium at a nominal rent. The petrols, there would then be a sublease granted out of the lease back to the petrol station, and the sublease would contain the covenants, the exclusivity covenants, so that the petrol company was tied, the petrol station was tied to buying the petrol from the petrol company. The payment, commercially, the payment for the tie was a premium for the lease. But of course, in legal form, it was a premium for a lease. And the aim, I think, of the petrol stations was to try and ensure that the receipts that they received were non-taxable capital rather than being taxable revenue receipts. That seems to have been the purpose of all this. Now, this appeal...
You mean?
Sorry?
The premium would be...
The premium, yes, the premium which they've received would be capital and therefore non-taxable. Whereas under the simpler structures, they simply entered into a contractual tie in return for an amount paid by the petrol company, and that was in danger of being a revenue receipt, as had been held in Bolam. This case was actually about whether the payment was a capital payment from the point of view of the oil company. The oil companies wanted a deduction for these premium. They had succeeded in Bolam in getting deductions, and they were now wanting to get them in the cases where there was the lease and leaseback arrangement. Now, what you have to understand is that this case was argued on two bases. One, the fact that it's a lease really answers the question, because a premium for a lease is capital. But there was an alternative argument, which was, leaving that aside, these are still capital payments if you ignore the lease. Now, all of the the majority of the House of Lords decided that they were capital, and on the basis of the basis that there was a lease. But they also, I think all of them went on to consider what the position would be if there was no lease. And that's why this decision is slightly confusing, because there's a lot of discussion about permanence and length of time, etc., which actually was not relevant to the actual decision in the case. But it might have been of interest to the parties, because many of their arrangements were not lease and leasebacks, we understand. So I think the parties were rather wanting to get the answer to a lot of questions from this case. But they didn't succeed, I'm afraid. In any event, if we just look at what Lord Reid said about this. And that's 1467. This is a summary of what his conclusions. 1467, just letter C. In 2 of the 4 arrangements with which the present appeal is concerned, including much the largest transaction, the ties were for 21 years. In 1, the tie was for 10 years, and the 4th, it was for 5 years. I would have no doubt that the lump sums paid for the 21-year ties could not be treated as revenue outgoings, even if there were no lease and sublease. These ties were not obtained in order to facilitate planned marketing, or because the appellants thought it desirable to have them. The lump sums paid for them were only paid because garage owners were in a strong bargaining position. They wanted and were able to get large sums paid immediately, and they were willing to grant long ties in return. But with regard to the other 2 cases, I must consider what difference it makes that the transaction took the form of a lease and sublease. This is not a mere matter of form, because this form of transaction gave to the appellants much better security for the performance by the garage owners of his obligation, and it gave to them interest in land which afforded that security. So the quality of their asset is different from what it is under the older form of tie. That was the older form where there was no lease, sublease. I've already said that all relevant factors must be considered in each particular case, and I regard this as a highly relevant factor. Premiums paid for leases have always been regarded as capital, but we will not refer to any case where a premium had been paid for a very short lease, say 2 or 3 years, and I do not wish to decide whether even such a case a premium would necessarily be treated as a capital outlay. But I'm satisfied that the weight of this factor in the present case is sufficient to turn the scale if otherwise there were doubt, and I would therefore hold that in each of the 4 cases the lump sums paid by the appellants cannot be allowed as revenue outgoings. It follows that these appeals must be dismissed. And in Lord Morris, he deals with it the other way around. If you just glance down page 1468, he decides that on the basis of the lease and sublease, you'll see. It's page 1468. It's the first page of Lord Morris's speech. And it's particularly the second paragraph.
Forgive me, but I'm not quite sure what we're really getting out of this case, because there's no dispute in this case that a payment for a capital asset is a capital payment. I mean, in the case before us.
Yes.
Isn't that what, I probably missed it, but it seemed to me that's what the House of Lords was saying in this Regent Oil case.
That's what they're saying, but I think the main thing you get from it is the fact that if it's a payment for a capital asset, that's a capital payment. Yeah. If it's not for a capital asset, then you might have to do what the House of Lords have done in the alternative, which is to look at a lot of different factors as to whether it is capital or not. That's the analysis that they were carrying out, Lord Reid was carrying out, and Lord Morris then goes on to carry out, and the others do as well in the alternative. assuming that there was no lease, they say. They carry out this balancing exercise looking at all the different factors, etc.
So if the owner of the petrol filling station had engaged an agent to negotiate to acquire or to grant a lease to the oil company and then engage lawyers, that would have been a capital.
That would be capital, yes. Yeah, it would follow on from that, exactly. And equally, the other side would no doubt engage professionals as well. There's bound to have been some professional fees involved in producing these.
But if the advice had been as to whether, I mean, they presumably got advice at an earlier stage as to whether they should move from the earlier purely contractual Bolam type arrangement to this lease arrangement, and what would be the advantages and disadvantages. Now, how would you categorise that expense?
That would be revenue. That would be part of their, part of their trade in deciding how to carry on their trade, essentially. Absolutely.
And so transpose that into this case. If there is a high-level review of all the investments held by the appellants, that's not a capital item. That's right. It's a management expense.
And there must have been such a review to come to the decision to sell. Originally, there must have been something. I don't think we have much information about that, but there must have been. That must have gone on before 2009, the June 2009 decision. There must have been extensive, one imagines, advice and consideration as to what they should do about the Oxo business. Whether they should lend it some more money, or whether they should get rid of it, or whether they should liquidate it, or I'm sure all sorts of options were considered, no doubt.
In this case, with the petrol ties, is there a point which we reached, you say, in this case in February 2011, where any advice ceases to be expenses of management at all and just becomes the implementation of the decision?
If this is not, obviously these are not investment companies, but so it wouldn't be relevant to them.
I know, but just as
if they were, well, if there is such a line, we don't recognise that as being a significant line, but I'm sure there would be a time when they must have raised this matter, one imagines, negotiated whether there was going to be a lease and lease back, or what was going to be, because no doubt we know from especially in the case, Regent Oil were not keen on this idea for obvious reasons. There must have been a stage when they were persuaded, and then they were actually drafting and signing the leases, I guess. We say that's not the cut-off point. Can I just then show you one more part, which is really about repetition, etc., which is in Lord Wilberforce's speech here, page 1491. The bottom of F, the payment was, though in a sense once and for all, was really of a recurrent character because the necessity was evident that the leases would expire, would have to be renewed, and fresh expenditure of the same kind incurred. Sometimes an argument of this kind may have some force. For example, in the Vallombrosa case, the expenditure, although described by Lord Dunedin as once and for all, was accepted as revenue expenditure because it related to a subject matter, namely weeding. This was the rubber plantations, Vallombrosa. Weeding, which in its nature does occur every year. Or in the Rhodesia Railways case, where the expenditure related to the obviously continuous matter of repairs. Conversely, in other cases, the argument fails because the expenditure is clearly capital in character, as for example when it's on plant, such as the knives in Hinton and Madden. That was a butcher's shop. There was a butcher's company who owned lots of shops and regularly moved into new shops and would sell their knives, etc., and buy new ones. And they were trying to argue that this was on revenue account, but these were capital items of the butcher trade, and therefore they were held to be capital, so they couldn't deduct the amounts that they paid to buy new paraphernalia for the butcher shop, such as knives, etc. I don't know where, I'm not quite sure where Lord Rose got knives from, because I don't find it mentioned in the case. It's all about, but I suppose that's what it was about, perhaps. And he goes on to say, a mere repetition of capital expenditure cannot turn it into revenue expenditure. That's the point I was making earlier. Of course, repetition can lead to the conclusion it's trading or dealing, but that's a different question. So that's stricken. The other case, and I may not have to look at this in much detail either for the similar reason, is Tucker and Granada. And this is the case where Lord Wilberforce sets out, explains the identifiable asset approach, which I think may be common ground between us now. And this is at page 1544. Just below letter C, I think that the key to the present case is to be found in those cases which have sought to identify an asset. In them, it seems reasonably logical to start with the assumption that money spent on the acquisition of the asset should be regarded as capital expenditure. Extensions from this are first to regard money spent on getting rid of a disadvantageous asset as capital expenditure, and secondly to regard money spent on improving the asset or making it more advantageous as capital expenditure. In the latter type of case, it will have to be considered whether the expenditure has the result stated or whether it should be regarded as expenditure on maintenance or upkeep, and some cases may pose difficult problems. And Lord Wilberforce is right, because there are a whole lot of cases, not particularly interesting for this purpose, but a whole lot of cases on the distinction between repairs and improvements. Repairs being revenue and improvements being capital. And there can be a difficult dividing line in some cases. Obviously, in many cases, it's obvious whether it's a repair or an improvement. But that can be a difficult area. I would certainly, I'm not going to read it all or go through it all, but I would certainly suggest that it's worth reading Lord Wilberforce's speech in this case as a general explanation of the concept of capital. If we come down to 1445, where he says, just a G, finally, I come to Anglo-Persian Oil and Dale, the sheet anchor of the appellant's argument. The payment there was in order to free the company from a long-term agency agreement which had become onerous to the company. Now, there may not be much commercial difference between a payment of this kind and a payment to get rid of an onerous lease, but since the courts have accepted and worked the identifiable asset test, the decision was no doubt right in law. The test may, to some extent, be arbitrary, but it provides a means which the courts can understand for distinguishing capital and income expenditure, and I think would be wise to maintain it. So Lord Wilberforce is accepting that this simple approach can be arbitrary on occasions, but it's easily understood and easily applied. So then, given, as I think my Lord says, it's accepted that expenditure on the disposal of a capital asset is capital, what is there in the particular circumstances of this case that take it out of the ordinary What factors do Call point to? First of all, they point to the scale of the investment business and contrast what it calls the relatively minor aspects of the Oxio investments. That's at paragraph 27 of their case. But of course, this is a substantial investment. You've seen the findings of fact in relation to the amounts of money which Centrica had to inject into Oxio, hundreds of millions of euros. It was sold for 96 million euros, I understand, on the 1st of June 2011. It's certainly not de minimis. But there's no concept of size in relation to capital assets. As we've seen, knives can be capital assets. So it doesn't stop them being capital assets, and it can't make any difference to the analysis, we would say. There is also the paradox that the taxpayers at one time say how minor Oxio is, but at other points they emphasise the large and difficult transaction that was engaged in selling it. And that's at paragraph 57 of the First Tier Tribunal decision. And at paragraph 148, they assert that a capital asset has to be fundamental to the organisation structure of Centrica's business. For the reasons that I've stated earlier, that's simply not correct. The capital asset does not have to be in any way fundamental. That is a misapplication, a misreading of the case law. Then the second point, the regularity with which Call incurs expenditure on services of the type here in question. They make this point at paragraph 144, 7, little 7 of their case. We would certainly agree with your lordships that there don't seem to be any particular findings of fact about regularity. But in any event, it is irrelevant. As Lord Wilberforce explained, what the court were talking about in Atherton and later cases was expenditure which is recurrent by its nature. That is something like, example there being weeding or repairs. Lord Wilberforce made it clear, and there are a number of other dicta in other cases, that recurrence of capital transactions does not make any difference. You can have 100 capital transactions, and they're still all capital. The only way, it's only relevant if you tip over the line into trading, and then you're in a completely different regime. And then we have the third thing is the number of different options that were contemplated. It seems to be said that because the mechanics of the sale were not clear from the very beginning, that somehow that makes a difference as to whether this is a capital transaction. First point to make is that all the options, all the methods of disposing of the Oxio business or part of it were capital transactions. Whether you were selling the business or whether you were selling shares in a company which owned the business, these are all capital transactions. And we would suggest that it is commonplace in any kind of sale of any complexity that the parties will have to consider the mechanics of the sale process, and that will not be fixed from the beginning. Those of us who have to advise on these things will know that you may spend many long hours discussing different ways in which a disposal might take place in order to accommodate perhaps the purchaser and their requirements of tax or regulatory or commercial requirements, and how that will affect the tax position, perhaps, or the regulatory position of the vendor. And there may be options as to selling through a company or selling assets, or in the case of land, granting long leases, etc. In our submission, none of that makes a difference. That is all an integral part of a sale process, and advising and discussing that kind of thing, and then implementing it as part of the sales process. And we would submit it doesn't make any difference to the nature of the expenditure, whether the mechanics which were alighted on in the end are different from the mechanics that were envisaged earlier on in the transaction. And one of the things, of course, you would consider is whether to take the asset off the market. We would suggest that that kind of consideration is all part of the sales process. Obviously, if the decision is taken to take the asset off the market, then the sales process will end at that point. It will be an abortive sale, and then it may well be that if it's an investment company, they will incur lots of expenses of management in deciding what to do thereafter. But if the sale carries on and goes ahead...
Those would be of a revenue nature.
Sorry?
Those would be of a revenue nature.
Those would be of a revenue nature, exactly.
But the costs they had incurred up to the date when they'd taken it off the market would be...
Would be capital, yes. As I say, it's well accepted that you can have capital expenditure on a transaction that doesn't take place in the end.
What is the authority for that?
There is a case in the bundle, I think, where that happened. Is
You
it?
don't need to go to it, but if you could just...
Oh, right, sorry, yes. One, ECC Quarries is one example of that. In fact, they didn't succeed in that case. But there are other cases I can you know... we can provide, yes. But it is, of course... It's obviously logical. It can't change its nature because you've aborted it. And sorry, so and finally, and I'm not sure whether this is a separate point. Cole makes the point that...
well, could you apportion some of the costs? So if you had a situation where a person owning an asset is uncertain as to whether or not they want to sell or not, and they're going to test the market, and they engage professionals to advise them about that. So some of the costs incurred are about selling it, and others are about just taking a broad view as to whether or not it's a wise thing to sell.
Possibly, or it may be in some cases that testing the market may not, in fact, be for the purpose of disposing. So you might say it's not capital, and that'd be an interesting case, I can imagine, to discuss, to debate. But yes, in principle, if it was not a genuine sale, then you might say, well, it's all just part of the process of deciding what to do. And the final point was the fact that Cole didn't end up disposing of any asset is made a point of. Cole themselves didn't dispose of any asset. But of course... That's
a high degree a technical point, because if you fillet the company of its principal businesses, you may not have sold an asset because you still own the shares, but you've taken value out of your asset in a very substantial way.
You are, well... You actually may have improved the value of your asset.
Oh, it depends, yes. It depends on particular circumstances.
Yes, but if you dispose of a business that's hemorrhaging money in return for cash, that might be an improvement.
That could be an improvement.
Yes.
But it's a very technical point to say, but I still own the shares.
Yes, but particularly technical in the context of this case, where Cole's business part of the Coles business is to procure transactions by group subsidiaries, where those transactions inure to the benefit of the group, and that's paragraph 28 of the appellant's case, where they set out what the business is. And it's because of that, of course, that they were able to claim these as expenses of management at all, because of course they were expenditure on someone else's business, on the business of the company, the Oxio company. But because because Coles' business of managing its investment partly was to be involved in and procure transactions by the subsidiary, then it was able to claim these as expenses of management. So it seems, in my submission, they can't then say, well, it can't be capital because we didn't dispose of anything. Sorry. So those are my submissions. There's just one point I think the Revenue were keen for us to correct, which is not quite wholly accurate in the case. In paragraph 32(1), we say that the HMRC estimates it currently allows 20 billion of relief under this provision.
32.
Sorry, it's paragraph 32, little Roman 1.
Yes.
And it's the words actually they're in bold. I think 20 billion under this provision. I'm told that it's strictly speaking not. Some of it is for life assurance companies, which is not strictly under this provision. It's still, yeah.
It's still a lot.
It's still a lot, yes. Yeah. Sorry. That was. So unless there's anything I can assist you with. Those are my submissions.
Thank you very much, Mr. Ewart. Mr. Rivet.
My lord, my ladies, one of the functions of a case before the courts, in common with most areas of human endeavour, is that hindsight can sometimes impose an architecture upon a series of events that is not evident at the time at which the events or transactions themselves take place. There was a very interesting exchange that occurred this afternoon on, for your transcript purposes, page 127 of the transcript between my Lord Richards and my learned friend. Lord Richards.
Do we have a transcript? Sorry.
You do have a transcript, my lord, and we'll make sure that it's available to
Yes,
you.
it becomes available to us after the event.
I'm very grateful, in which case I shall simply explain what the exchange was.
But we know which page to look for.
Thank you, my lord. The exchange was as to whether there was a point in time prior to June 2006 in which decisions were made in relation to this investment. 2009, forgive me, in which decisions were made in relation to these investments. And my learned friend was asked how expenditure in relation to that category of investigation of the investments would be characterised. And he said, unequivocally, that would be identified as being revenue expense. And he then went a little bit further and said, I don't think we have much information about that, but there must have gone on before 2009, the June 2009 decision. There must have been extensive, one imagines, advice and consideration as to what they should do about the Oxio business, whether they should lend it some money, whether they should get rid of it or liquidate it. All sorts of options were considered, no doubt. And my simple submission is that that is where the fault line between my learned friend and I arises in relation to the facts of this case. I'll come to the bright line effect of the June 2009 decision in a moment. But in my submission, the advice that was being, the findings of fact that were made by the FDT indicate that, so far as concerned the expenditure before your lordships and your ladyships is concerned, advice was being taken from service providers in relation to precisely those sorts of decision after 2009. And the mere fact that hindsight imposes an architecture upon this to the point that we know that ultimately the business was sold does not change the nature of the advice that was received.
But you didn't run the case. You didn't run the case that you could split up the costs in this way. It just simply wasn't done.
My lord, it's, if I may, the difficulty with it is that the way in which the proceedings arrived at the tax tribunal, which is what the FTT resolved upon, was that a date was picked up at which it was accepted by the taxpayer that the quality of what the individuals were doing changed. And that may have been a shorthand reason. I think my learned friend would not disagree with me that simply the imposition of a bright line test as to a particular date can't be relevant, because it can't be the case that on a particular date, if you decide to sell an asset, if you receive a load of advice in relation to something which isn't actually concerned with the sale itself, but performs some other function in your business, that automatically forms to the capital side of the line. As I understood my learned friend, actually there was quite a lot of degree of agreement with us about what the correct approach to the analysis is in terms of what the expenditure is. The first point is we look at what the expenditure was actually on. And what my learned friend says, as I understand it, is that following the June 2009 decision, the colour of the advice that was being given, or the nature of it, was of a quality that it was linked, I'll come to quite what the test is for that in a moment, to a capital transaction, and therefore should be regarded as falling within the exclusion. And my case is that the authorities in the trading context make clear that you have to look in every instance as to what was the nature of the advice and to what did it relate. And simply picking a date and saying, well, a decision was made to sell in June 2009 and therefore everything that happened after it related to the decision to sell and was therefore capital, is with respect to focus the telescope at too great a distance. One needs to have a more close examination of what was actually going on. And if one sees this, in a sense it goes back to a point that my Lady Simler was making this morning. I accept that the high watermark of my case on the facts was the findings that were made in relation to the deep dive on the PwC case. But if we could just look at those for a moment, it illustrates one of the difficulties of adopting some kind of brittle date upon which the characterization of a particular form of expenditure changed here. And you can see this in particular at passages, for example, page 100, paragraph 100 of the FDT decision. Page 326 of the decision, and 327 of the decision. This is the discussion. There are two reports we've heard mention of, the vendor due diligence report, and a number of observations were made about, well, this was all for the, this was for the benefit of a prospective purchaser. But that's not what the findings are made by the FTT.
Well, it's not, isn't it? Look at the last sentence of 96.
My lady, but then that has to be read as well with 105. And I apologise, it's just none of these findings are brittle or hard-edged. The tribunal heard evidence over a number of days from a number of witnesses about what all of these services were and what the advice there was that was received at particular points in time. And the impression one gets...
I'm saying that some of the advice was not directed towards achieving the sale which the board in principle had decided upon in June 2009, but had a broader purpose.
Well, my lord, I'm saying that in my submission, and I recognise that my learned friend's case is the opposite of this, one can't analyse it at that level of abstraction, simply saying...
I was not doing it at a level of abstraction. I was trying to identify piece of advice by piece of advice, what it was aimed at achieving.
Yes, well, my lord, what I say on that is the points that I was making this morning by reference to those passages at the end, that what the advice was, for example, the finding at 427, the PwC VDD report, and in particular the deep dive, so both of those, for example, was advice which gave the management of coal an insight into the nature and extent of the problems in the Oxio business and informed the decisions about how to deal with its investments. I mean, it's worth recording that, of course, the findings of fact are that within a few months of having made the apparent decision to sell the assets, a decision was made to extend a £250 million revolving credit facility to one of the subsidiaries. That's recorded as a fact. There are all sorts of things that are going on.
But you're ignoring the point made at 105 that it was produced primarily for prospective purchases. It might have had incidental benefits for the board to know about the weaknesses, but the primary purpose of it was for purchases. And PwC was given access to management records and accounts in order to produce what was effectively an independent report by way of due diligence for potential purchasers.
My lady, there are two points in relation to that. The first is that I accept, of course, it says that the primary purpose of that, but the other use of it was more than less than, as it were, incidental, because if one looks at the finding on 427...
Paragraph
427, where the tribunal is disposing of the question of capital, the VDD, the vendor due diligence report, and in particular the deep dive, was advice which gave the management of coal an insight into the nature and extent of the problems in the business, well, and that reflects.
It ignores the primary purpose.
It may not be inconsistent. I mean, there isn't an exclusivity provision in relation to the expenditure here in question. It may have served a number of purposes, my lady. And indeed, that was the evidence.
I mean, at the end of the day, you've got to arrive at an amount of pounds, which are the fees which you are claiming. Now, according to paragraph 106, PwC's submitted this very precise bill, including 60p, whereas Deutsche Bank, their bill was not broken down in that way. It was 5 million euros. But what I'm not sure about is if you had to go into the granularity that you're suggesting, how do you actually do that as a practical matter in relation to a bill which is pay us £2 million and we'll do the job? How do you know how much of that is deductible or not?
Well, my lady, the answer is that on a strict reading of the authorities, I would have to accept that one has to account for whether or not Mr. Smith or Miss Smith was at this hour of the given day producing advice for the purposes of enabling the company to make managerial decisions. Should we extend a credit loan? Should we? What are the problems with this business? How can we fix these business? Or whether or not what Mr. or Miss Smith were doing was advising on the structure of a particular transaction. But the evidence before the tribunal, we don't have, given the nature and the extent of the expenditure here in time, we don't have 6 months to do that exercise, and so shortcuts were taken by the tribunal. And with respect to the tribunal, what the decision sets out is the result of their analysis of a huge amount of evidence that was before the tribunal about what particular service providers were doing at particular points in time. But I accept, my lady, that in the Council of Perfection, on every line item, every pound, one would have to be analysing precisely what was going on in relation to it. What happened in practice, it goes back to my Lord Stephen's point earlier, was that in these circumstances, the taxpayer took a pragmatic attempt to do a time apportionment at one point in time. It went to the tribunal in circumstances where that time apportionment had already occurred. And then what happened is the tribunal used various staging posts to identify that the thrust of the activities of what was going on by these advisors changed.
The problem I see is with a deep dive report, if you're trying to separate that out, is that it's a report which is aimed at one of the issues is whether the problems were so bad that the business was unsellable. So that's advising your client in relation to a sale process. It's unsellable. And thereafter, if it was unsellable, it would still be a capital item expenditure.
Well, my lord, in a sense, we might be back to the questions that were being asked earlier about the difference between purpose and effect of it. I mean, the effect of the expenditure on the deep dive, there's nowhere, I think, in the engagement letter or at the outset in June 2009 that identifies that PwC are going to be taking a deep dive in relation to this. What happened is that as events carried on, everybody realised that Oxio was rather more complicated than they had thought to be the case formerly.
So, I mean, in the previous paragraph, 426, just focusing on Deutsche Bank, in the second sentence, the tribunal says, in the case of Deutsche Bank, that was strategic advice on the options for disposing of this difficult asset and assistance in finding a purchaser who would be prepared to make an adequate offer for at least some aspects of the Oxio business. So that's the summary there, the one-sentence summary, identifies Deutsche Bank as engaged to enable and effect the proposed disposal to take place. Then they say, or the tribunal says in her view, the costs were part of the ongoing management expenses, and that's the issue of principle which we have to decide.
Yes, my lord. If one turns back to page 71, though, one of the options that's being considered by Deutsche Bank, paragraph 71, is the possibility that the business wouldn't be unsellable and would have to be closed down. All options were on the table at the point at which they were brought in.
Well, I mean, I'm bound to say that when you say that it's your case that the tribunal must look at the nature of the advice and to what it related, that it seems to me is something that the tribunal should be asked to do and should do. We shouldn't really be scrabbling around all these findings to discern what the facts are. But I do look at paragraph 426 and the conclusion that the tribunal comes to, having heard all this evidence, is as stated in the second paragraph, and I don't think in the second sentence of that paragraph. And the point of principle is whether that sort of work, payment for that sort of work, is an expense of a capital nature in circumstances where a decision in principle to dispose of the Oxio business, or as much of it as possible, has been taken, but there has not yet been identified a particular purchaser, and they're not at that stage implementing the particular disposal. Now, that's a point of principle which it is proper to bring to this court.
Yes, my lord. And that is...
And we haven't, I mean, sorry, just to carry on a bit, I haven't understood the case to be presented on the basis that some sort of distinction is to be made between Deutsche Bank on the one hand and PwC on the other, or indeed as to different parts of PwC's work. It all stands or falls together, doesn't it?
It does, my lord, and I accept that. I don't seek to draw a distinction on that basis. It wouldn't be proper for me to do so, because my case is that all of the disputed expenditure...
Even if, so looking at 426, you say the first-tier tribunal was correct in the conclusion it reached in the last sentence of 426 on the basis of its summary of its findings in the second sentence.
I do, my lord.
Yes, I understand.
And I say that for the reasons I've advanced before.
Yes,
there wasn't the magic in the June 2009 decision that my learned friend says exists.
Because it isn't they haven't got a purchaser.
Exactly. Or they haven't actually got it's not even a purchaser. They don't even know what the transaction is. They just want to deal with that asset. The second point, if I may very quickly, was to deal with Marks and Spencer. With the greatest of respect to my learned friend, the difficulty with Marks and Spencer's is that it rather illustrates the problem of trying to rely upon other facts and circumstances here. That was a radically different set of facts that were being considered. I accept the purity of the principle, but the difficulty is Marks and Spencer's business consists in the selling of groceries and in the selling of clothes. It doesn't consist in the holding of properties for it to generate investment income. And so what constitutes capital or revenue expenditure in that case will be very different to that in circumstances where we do hold investments to generate income from them. I've made my points regarding the bright line. In my respectful position, I can see why that might be a useful surrogate for investigating the quality of what you were being advised upon at a particular or a shortcut, but there can't be a principle along those lines, because you might equally incur revenue expense after that decision is made or otherwise. It just depends on what does the advice relate to. Two small points. Well, one very large small point. The 21 billion. I don't think my learned friend quite rightly accepted that he's giving evidence. We don't know how those figures were arrived at or what the basis of. We don't know to what extent taxpayers' returns were made on the basis of the upper tribunal's decision in this case, or the Court of Appeals. So with respect, we accept that this relief is very important. But quite what the figures are, or how they were calculated, we don't agree, necessarily accept that figure. And the final point was a point that was made by my Lady Rose regarding the explanatory notes. Your ladyship asked the question about paragraph 10 of the explanatory notes to the bill, and you made the point that on the face of the drafting there in question, it looked as if the intended effect of the terms of the bill was to prevent a sum which was capital expenditure from constituting expenses of management, not that which you see in the enactment now in force. My lady, with respect, was absolutely right. When that provisions of in 2004 were introduced, that was what the earlier version of this legislation said. It stopped it from being an expense of management in the first place. And you can see that from the legislation that was put in force then, which is in the bundle. I'm not sure that any great matter turns upon it, but just...
I mean, what was enacted was different from what was in the bill.
Well, my lady, sorry, that was unclear. What was enacted was the same as was in the bill, but is different to what is in force now. The language was changed as part of the rewrite. So if one looks at the authorities bundle, I'm sorry, I'm very conscious of the time. Yes. I'm not sure that anything turns on this, my lady.
I'd like to have the reference.
Thank you, my lord.
So would I.
The reference, if I may, so that...
Where do we find the...
have you got the page? Brilliant. My learned junior points out it's at page 1080 of the bundle. And if one looks there, the Finance Act 2004, Section 38. And if one looks at Section 75, which is the amendment that's made by it, subsection 3, expenses of a capital nature are not expenses of management. Now, when we come to the rewrite, it's the point that my Lady Rose, I think, was making regarding the terms of the explanatory notes that were made earlier. When one look at the rewrite now in force, it says something rather different, which is, if one turns to page 1117,
no deduction is allowed. Expenses.
Precisely, my lord. What it doesn't do is tell you that you haven't got management expenses in the first place.
I mean, actually, it's in Section 75(3) is a statutory enactment of the revenues big submission in the Camas case.
It's closer, exactly, my lord.
Well, yes.
Yeah.
But still, it's a change of language rather than substance.
It's a change of language. And I fully accept that I don't think that for the purposes of today, anything turns upon the rewrites, reuse of the language. I'm just anxious that...
Right, but because it doesn't matter for us whether it's an expense of management or not. If it's of a capital nature, it's not deductible.
That's right, my lady.
Yeah. But whether it matters for any other purpose somewhere in the tax code, who knows?
It's rather the same. It's the same point about the arguments about the identity of the language in Section 53. It's not identical. We're talking about expenses of a capital nature here, and in the trading section, Section 53, it's items of a capital nature. Now, nothing may turn on it for this case, but the language is different. My lords, my ladies, unless I can do further.
Thank you very much.
Thank you.
Well, it only remains for the court to thank counsel for their clear submissions in this interesting case, and also to thank those who sit behind counsel for their work in preparing the papers and arguments which we have heard today. The court will take time to consider how best to respond to your submissions. We will now adjourn.